The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Please be seated. We are here today for 2 oral arguments. The third case will be submitted without oral argument. The first case set for today is Kenneth Doss versus the State of Iowa. The second case is PSFS3 Corporation versus Seidman et al. And the third case that will be submitted without oral argument is Iowa Supreme Court Attorney Disciplinary Board versus Stephen Newport. So we will begin with the Doss case versus State of Iowa. And Justice Apple is participating remotely. I'd like to do a really quick sound check with him just to make sure that he can hear us okay. So representing the appellant, Raya Dimitrova. Did I pronounce it correctly?
Yes, Your Honor.
Thank you. Would you please do a quick sound check?
Good morning. Can you hear me?
I sure can. Thank you.
Representing the state, Thomas Bakke.
Good morning.
Thank you very much. I can hear you.
Okay. Ms. Dimitrova, you may begin when you're ready.
Thank you, Chief Justice Christensen. May it please the court. Counsel. Kenneth Doss remains incarcerated today, more than 13 years after his original conviction for having a girlfriend and using the internet. Now, having personal connections or a job that perhaps give you a sense of purpose in life, these are all things that we know to be essential in rehabilitating an offender. Reintegrating them back into society by going to church and forming these social connections that turn out to be our support systems, or going to therapy, for example, to deal with the issues that led us to the original offense to begin with. These are all wonderful tools used to reduce recidivism rates. Yet the Iowa Board of Parole has put a complete ban on these in Mr. Doss's case without giving him any individualized consideration to his character or his offense. Now, it is difficult to understand how these blanket restrictions serve the rehabilitative or the deterrent purpose of his special sentence. Now, these are the practical implications of this case. Let's move on to the constitutional analysis.
While we're talking about the practical part, you say that he's back in prison because he used the internet. Well, according to his parole revocation report, he used the internet, but it was specific things he did on the internet. He was, these were hookup sites, and he was, and pornography sites and things like that. And he was a sex offender who was supposed to be in the middle of sex offender treatment. You know, isn't it logical for the parole board to be concerned in those, or the parole officer to be concerned in those circumstances?
Your Honor, Mr. Doss does not challenge all of the rules that apply to him on his parole and special sentence. He challenges specifically the 4 rules that ban his total use of internet, total ban on dating, total ban on going to church, and using his outside form of canceling. Now, certainly within the examples that you gave that he used the internet, he used them for dating purposes, which he violated both of these rules that we're challenging today. We challenge these rules because they restrict his fundamental rights protected under the United States Constitution and the Iowa Constitution.
Can I circle back to Justice Mansfield's question? And my question is whether or not this is the proper vehicle to address the constitutionality of the contract restrictions if the only thing at issue here under 822E is actually the legality of the revocation. And I assume that you would agree that as applied to Mr. Doss, a prohibition on using the internet for accessing pornography would be constitutional.
Sir, I'll start with the beginning of your question. Certainly, we do believe that post-conviction relief in this venue is the appropriate mechanism to challenge the constitutionality of these convictions. Now, the state certainly argued that he has Chapter 17A available to him. However, the problem with these restrictions is that they are put on at the beginning, that he has no negotiating power, and they apply to every single person. So certainly Iowa Code Chapter 822.2 sub 1 sub E allows for post-conviction relief to be the proper venue to litigate these, and this court in the LeMaster's case actually decided that even though we do have these remedies in Chapter 17A, and they have the exclusivity clauses there, like I believe on 3 sections they say that this is the exclusive means, then if we follow that rationale, then Chapter 822, that particular subsection in there, would not serve any purpose, and certainly the legislation intended it to serve any purpose.
But isn't the specific question, though, whether the revocation under these circumstances was constitutional, and then we have to look at the specific grounds of revocation versus the broader prohibitions contained in the parole agreement and the SOTP contract?
Well, Your Honor, we challenge these conditions as they apply to him. Now, are they broad? Yes, absolutely. Do they appear on their face to be unconstitutional? But we challenge them as they appear specifically to him. Now,
If I'm wrong, but is there anywhere in the record that he ever asked for them to cut him a break on something?
no, Your Honor. The record is clear that he did not ask. But however, that goes to the prior point that I made, that these conditions are put to him, and they condition his liberty. The parole agreement says you need to sign this or you remain in prison. And a year later, when he was presented with the SOTP contract, he had the same choice. You have to sign this and comply by these unconstitutional rules, or you risk revocation and going back to prison. So his negotiating power against the actual body that put these conditions in place is non-existent at that point in time.
He didn't even try to negotiate, did he?
When
you say he has negotiating power, I mean, you got to try to say you have negotiation.
Well, certainly, Your Honor, but in this scenario, we leave Mr. Doss's fundamental rights at the grace of his parole officer. And certainly that negotiation is not fair on his side. Now, we cite to the Packingham case, which is a relatively new case from the United States Supreme Court and dealt with the restriction on the internet, specifically in the context of the protected speech under the First Amendment. And that case told us that even in the scenario where we have convicted sex offenders, we cannot put these broad bans, and told us that we have to use the heightened or intermediate scrutiny and subject any of these restrictions or laws to be narrowly tailored to serve a significant government purpose. Now, in the internet scenario, I don't disagree that the government has a significant interest in protecting the public from sex offenders who use the internet to prey on their victims, absolutely. But when you apply this case, this principle of Packingham to the case in hand, there's nothing in this record that shows that Mr. Doss used the internet or anything about his personal characteristics that tells us that the internet would be something he would use to continue on his criminal activity. And in any event, the means that the government used in this case burdened substantially more speech than it was necessary to further that interest. Now, admittedly, courts are divided. The federal courts are divided as to whether the rationale and the principle in Packingham should apply to parolees. And if this court believes that we should apply this to parolees, I think the analysis is very clear. Let's take a look at the court cases that actually did not apply it. The Carson case, for example, and the line of cases in Carson, even though they said Packingham does not apply to parolees, what they did is they still used a statutorily prescribed balancing test that requires the district court to make a specific finding that the condition that they put in place on a person who's about to go on supervised release has to be reasonably related to a set of factors, including individual's characteristics and the nature and offense of the nature and circumstances of the crime. And in any event, they should not provide greater deprivation of liberty than is necessary to deter criminal conduct. So when we apply even this less stringent balancing test, Doss's conditions still don't pass constitutional muster. Because again, our record is void of any suggestion or any evidence that there has been any individualized finding made before the Board of Parole required him to not use the internet, before they told him they cannot date anyone, cannot go to church, or he cannot use his own form of counseling.
He didn't give him much time to ever have something to look at. Didn't he almost always immediately do something that got their attention? I mean, there wasn't like he went a year without any troubles, and all of a sudden he's on the internet for something rather innocuous, and then they nail him with a revocation. Wasn't it pretty quick upon his release that he was using internet and some of the other activities?
I would still say that the record is not necessarily very clear on the timeline, but even if that is the case, even if he violates it, the Constitution doesn't put a time limit on how long we can allow someone to violate constitutional rights. The fact of the matter is that these are immediate upon his release. So whether he uses it the next day or 2 days after that, it's still the constitutionality or unconstitutionality of these rules attaches the minute he signs them and he's not given a choice.
But being paroled is a privilege. You're getting out early under some certain conditions. So doesn't it kind of make sense that there might be some restrictions that might not apply, of course, to another person of a different crime?
Certainly, Your Honor. But again, even within your question, I believe that if they would not apply to somebody else with a different crime, that still requires some sort of a tailoring or individualized finding as to why this particular restriction would serve the government purpose when it comes to that particular offender.
And I go ahead.
Oh, thanks, Counsel. How do we know that if he had simply asked his parole officer, hey, I'd like to go to church, he would have gotten a sure go ahead? Is this case ripe when he made no effort to ask permission to do any of these things?
It is, Your Honor, and again, I'll go back because the immediate nature of these rules. Now, again, I would submit that even his parole officer in the testimony tells us that these are the rules that apply to every single person. And in fact, once they impose them, after that, they use this time to, I believe he characterized this as an evaluation time. But
the rules provided a mechanism for him to ask permission to do specific things, and he never tried that.
Well, and again, Your Honor, he doesn't hold a negotiating power against the body that actually put these conditions in place and told him these are the standard conditions in place. So the argument that he makes today is that he has no negotiating power when it comes to his parole officer. For example, it goes to Mr. Swyman and says, can I use the internet? No. That's the end of the negotiation.
Wouldn't it be more persuasive if you could say that? He asked and they said no?
For the purposes of a constitutional argument, Your Honor, no. The fact that these rules are put in place at the beginning and they condition his liberty on it, no, it would not change my analysis.
Counsel, was Mr. Doss, his special sentence, was that the 10-year special sentence or the lifetime special sentence?
No, Your Honor, he's subject to the lifetime special sentence.
And which way does that cut in the constitutional analysis? I mean, I know our statute says the offender serves the special sentence as if on parole, but he's not actually on parole. I mean, he's always subject to this special sentence. Is that correct?
That is correct, Your Honor.
And which way does that cut in terms of negotiating and the constitutionality of the conditions imposed on him with respect to this special sentence?
Your Honor, I just want to make sure I understand your question correctly. I do believe that it wouldn't change the analysis, and it would present the same argument that maybe it would strengthen the argument that because this is a special sentence and a lifetime special sentence, then being subject to these unconstitutional rights from the get-go and subject his limited liberty on him does not pass muster. Now, I would point out that even the Iowa Board of Parole that was invited to write an amicus brief in this case, although they didn't cite any specific case law to it, they kind of presented to us a different standard. They argue that the conditions imposed were constitutional because they were reasonably related to the offense or an identifiable need. Again, without any case law, I'm still submitting to this court today that Mr. Doss's condition would not even pass this test, assuming that it's lower than the federal statute and the scrutiny prescribed by the Supreme Court.
Let me ask another related question. I mean, most of what you're complaining about is not in the parole agreement, it's the sex offender treatment agreement, correct?
It is a combination of both, and I'll give you a quick example on it. I'm sorry, I know I interrupted your question.
No, please.
The ban on the internet itself is conflicting with the requirement of the parole agreement, then you need to go and obtain a job and maintain one. In this day and age, Mr. Doss must use the internet to apply for any job, even as a cashier at Walmart.
And I noticed in his parole revocation report where they talk about him being on these hookup sites and pornography sites, they say none of this is relevant to his employment or job searches. So it seemed like if they were relevant, that wouldn't have been an issue, right?
Certainly, that's, again, leaving that decision to the grace of his parole officer. We don't know necessarily that he was not going to still revoke.
Well, but one of the questions is whether he, in fact, had an individualized hearing. I understand that the policy itself is quite broad, but does the record show that, in fact, in this case, he got the individualized hearing that he was entitled to?
He did not, Your Honor. Nothing in this record tells us that he had any individualized hearing. Now,
well, but wait a minute. You say that, but
Justice Apple, I can't hear you.
Yeah, I'm sorry. My mute tripped on. But at the parole revocation hearing, they were talking specifically, as Justice Mansfield was exploring. They talked specifically about use of internet sites that we would likely say, would be a real problem for this kind of offender.
Your Honor, this comes in a different timeline. However, the problem is that this, even if we assume that this is an individualized hearing or a finding, this comes at the time of revocation. What needs to happen is that before we put these conditions in place, that's when we need to go through the individualized finding that they're related to his character or the nature of the offense. Now, we submitted to this court that the Iowa Constitution also provides protection to Mr. Doss in a broader way than the United States Constitution would. Under the Ochoa line of cases, we know that the Iowa Constitution already provides for greater retention of constitutional protections enjoyed by parolees, specifically in the scenario of warrantless, suspicionless searches solely based on their status of a parole. Now, the state's interest here in preventing reoffenses is arguably more closely aligned to being able to search someone rather than to restrict their speech or their right to association or their right to go to church. Now, we did submit another argument to this court.
You may wrap up.
Thank you, Your Honor. Second argument was that we submitted that his trial counsel was ineffective for failing to advise them and misadvised them of all of these conditions. And we would ask this court to remand this case to district court with direction to grant his application for post-conviction relief, which would then vacate the revocation of his parole and eliminate the unconstitutional conditions of his parole as applied to him. Thank you.
Mr. Bakke, when you're ready.
May it please the court, counsel. Good morning. Assistant Attorney General Thomas Bakke for the state. This court should affirm the denial of Kenneth Doss's application for post-conviction relief. I briefly want to address an internal conflict in the applicant's argument. Today and in her responsive brief filed last week, Doss's counsel has explained that she is not pursuing a facial challenge and that she is only pursuing an as-applied challenge as it specifically relates to his revocation and his ongoing incarceration. The problem with that is Doss does not explain why or how he is challenging rules that do not relate to his revocation in any way. Specifically, that would be the rules on attending religious gatherings and on participating in outside counseling. Those specific rules there is no allegation that he actually violated those rules or that his revocation was any way related to those rules. Thus, this court, if it addresses the constitutionality of the rules, it should only address the rules that possibly relate to the revocation itself. Turning then to the remaining rules. As the Board of Parole recognized in its amicus brief, this court should be hesitant to address the constitutionality of the rules such as dating, accessing the internet, because Mr. Doss was revoked for additional reasons that are not contested in Mr. Doss's application. Those violations include an unexcused absence from SOTP treatment, accessing pornographic materials, violating the sex offender registry, associating with individuals with criminal records, and unauthorized contact with a 2-year-old child. And those are on the PCR transcript, page 13, Joseph Swain.
Well, counsel, do we know that those violations would have been sufficient for the revocation? I mean, quite frankly, there's a kind of a laundry list, I guess, of problems here. But if you take out one, if we decided that it was partly unconstitutional, let's just say, where does that leave us? How do we know that for example, the failure to attend sex offender treatment meetings would have been sufficient to lead to the parole revocation?
Your Honor, I have a two-part response to your question. One, under the doctrine of constitutional avoidance, because there are additional grounds in an 822 proceedings, the revocation, the question is really whether the revocation itself was lawful. And as the Board of Parole explained in its amicus brief, if there's one violation, that's enough to revoke parole. But here we have multiple that are not contested.
I wonder if you're giving up too much ground, because I read the parole violation report that Mr. Doss put in the record. It was part of his PCR. And I don't see anything in there that, from a constitutional perspective, troubles me. In fact, the only grounds that are referenced are the ones that you are just talking about. Is there an additional ground that might be constitutionally troubling that he was revoked for?
It's our position that no, that there is no constitutional problem. I was speaking as a hypothetical. If this court does find constitutional problems, this is how it should proceed. That looking at the revocation report, there's numerous reasons that Mr. Doss is not even contesting today. That accessing pornographic websites is itself a separate violation of the rules, completely separate from accessing the internet. And he is not contesting that rule, and nor do the amici contest those portions of the parole contract, the SOTP contract. And in fact, amicus ACLU recognizes there's portions of this SOTP contract that would be legitimate, including limiting or restricting his contact with minors, which is a violation that Mr. Doss had in this case by having unauthorized contact.
The thing is, like, the minor thing is not just sort of, I think maybe the way Mr. Doss portrays it. According to the report, what was going on is he was living in a hotel room with another ex-offender. She had a 2-year-old son. This is within 1 month of his release from prison. He's supposed to be going through SOTP. He holds up the son for a photo with a text message telling the world, would you let me adopt, name of the son, in court so that he can have a dad who will be able to take care of him. You know I love him like my own son. That strikes me as something that would be totally inappropriate for somebody who's undergoing SOTP to be engaged in, right?
I certainly agree, Your Honor. And the purpose of SOTP is rehabilitation and to keep offenders from engaging in those high-risk sexual conduct that is going to lead them back down the path that led to their initial violation. That the goal of SOTP, as this court recognized in, I believe it's State v. District Court for Jones County, that SOTP has the purpose of that is a bona fide rehabilitative purpose. And so these rules are not intended as punishment. They're not intended on keeping Doss forever from accessing the internet. They're to keep him from having the temptations of engaging in that high-risk conduct that is problematic and leads to...
The state agree if there were a blanket ban on using the internet for the rest of Mr. Doss's life, that would be unconstitutional.
Yes, unless there's more to it, but yes, generally, I would agree with that. I will state...
So can I ask a follow-up to that question?
Yes.
And if we believe that a ban on internet access is unconstitutional on its face under Packingham, what is the authority for the state to impose an unconstitutional condition and then put the onus on the offender to ask for exceptions? That strikes me as problematic under the conditions doctrine.
I recognize that concern, Your Honor, and I very briefly want to touch on, you bring up Packingham, and Ms. Dimitrova brought up Packingham today as well. And this briefly addresses the issue of error preservation in this case. In the district court, Mr. Doss only addressed or raised his claim as one of the right of association. However, in his merit brief on appeal and in the responsive brief, he changed that argument to be one of free speech. This was never addressed. The Packingham case and the other cases cited all address free speech, and that is not something that Mr. Doss addressed in the district court, and that claim is entirely unpreserved for purposes of this appeal. The state recognizes the ACLU recognized that in its amicus brief and attempted to circumvent that by requesting this court to apply a liberal view of error preservation, and the state urges this court to decline that invitation. That if Mr. Doss only asserted the right of association in the district court, he should be limited to that approach on appeal.
Counsel, what's the state's take on the fact that he challenged this under 822 and not 17A?
Certainly, Your Honor. It's our position that, yes, an offender under 822.21e can contest the revocation, but it's our position that that challenge is limited to, was this revocation lawful? And that any collateral challenge on whether the underlying rules themselves were constitutional, that must proceed through 17A proceedings so that the Board of Parole's policy, if you will, can be contested through the Administrative Procedures Act.
Is that argument, though, now waived by the state since it didn't raise it below?
To an extent, yes, Your Honor. The problem with that is it's a question of authority, which this court has recognized can be waived. However, as far as Mr. Doss is attempting to raise new claims, challenge rules that aren't related to him, those facial challenges that aren't related to revocation, this court should decline to permit him to do so.
Let me try this on you and tell me if you agree. I mean, the state didn't raise a whole lot below, other than they argued these are just the normal conditions and, you know, Doss wasn't treated different from anyone else. That was sort of the gist of the argument. So it does strike me that the state waived 17A. On the other hand, this is still, always has been and remains a PCR, and all we can do is grant relief and review it under 822. And the only thing he can get is a reversal of his parole revocation. He's not entitled to, from this court, to a advisory opinion on different parole conditions. And if that's the case, then all we're reviewing is the revocation and whether it was proper or not. Is that?
Yes, I absolutely agree with that. This court is limited to reviewing the revocation, and I would urge this court go a step further and say that it's limited to reviewing was the revocation appropriate at all, not whether the underlying rules themselves were constitutional to impose. That was there a lawful basis for revocation?
Well, I mean, I think that might be a little narrow. If he was punished for doing something he had a constitutional right to do, that could be problematic, right?
Yes, Your Honor. However, it's our position that in this case that's not the issue. If Mr. Doss, the only violation he had was accessing the internet to file his taxes, that would be an entirely different question. There would be more concerns with that. But because we have those other grounds here, the other violations that he's not even contesting, it makes little sense to allow him to challenge those rules, to challenge the procedures. Essentially, what he is doing is saying, I'm going to ignore these rules, I'm going to violate them, and instead of challenging the rules or asking for them to be modified, I'm going to challenge the punishment after the fact. And that's what should not be allowed to happen.
Mr. Bakke, I understand the state's position with respect to error preservation, but can you address the merits of the issue of unconstitutional conditions? And is it the state's position that it is lawful for the Board of Parole to impose facially unconstitutional restrictions and then put the onus on the offender to seek relief by negotiating with the parole officer? Is that the state's position?
I disagree that these are entirely unconstitutional on their face, and that's
well, let's take the internet ban, for example. Is it the state's position that a ban, banning an offender from completely accessing the internet in any way, which is what this provision provides, is constitutional?
It's difficult to answer that, and I recognize the question. However, it's difficult to answer that in this case because what we're missing from this analysis, what we're missing from this record is why these rules are important.
He was in SOTP.
Under any circumstance, is it constitutional for the state to prohibit an offender for the rest of his or her life from accessing the internet? Yes or no?
I would say no, but the problem with that analysis is that's not what happened here because SOTP is limited in duration until the maximum benefits are achieved. But even beyond that, Mr. Das was only in the initial evaluation period before which the contract is modified, as the parole officer explained. But he violated before that modification could even happen.
But I guess my question is, though, why isn't the restriction more narrowly tailored from the outset? I mean, I think it's your position that this is okay, and then the onus is on the offender to negotiate some sort of lesser restriction that would meet constitutional standards. It's what you're saying, I think, right?
It's our position that that's not, in effect, what Mr. Das received, that he wasn't actually barred, as this court, as I believe it was Justice Mansfield recognized, that he was still, the ALJ wasn't going to punish him for accessing job searching websites, that it was not essentially a blanket ban.
Well, but counsel, you would agree that as stated, he could have, right?
That he could have been violated?
That's a violation. I mean, even though they decided not to enforce that, he certainly could have. True?
Yes, and I do recognize that the way this contract is worded, there appears to be substantial concerns. However, I will point out that Mr. Das did have the ability to negotiate this. And with respect to Ms. Dimitrova, the record in this case presents that the parole officer said, yes, these are negotiable, yes, they can get it changed. And she presents it as a question of asking the parole officer, he says no, then the negotiation's done, but that's not all.
One reason, I mean, I'm not saying it's constitutional, but it strikes me that one reason you might put the burden on the offender while they're, at least while they're in SOTP, to talk to the parole officer before they get on the internet is because then the parole officer knows they are on the internet and then and may find out if they have a username or an account with a particular ISP or things like that, and therefore will be better able to monitor in case there are illicit activities such as Mr. Das engaged in, right?
Right, and that's precisely correct, Your Honor, that by putting the parole officer on notice that, and Madam Chief Justice, if I'll have permission to continue answering.
Yes, please, you may answer.
That by putting the parole officer on notice that yes, he is going to be attending this group gathering, that yes, he's going to be dating this person who has a child. Oh, and by the way, she has a criminal record. That it gives the parole officer more information so that the goal of protecting the public and rehabilitating Das, so that those goals can be achieved. And I just very briefly want to notice that even if the parole officer said no, Mr. Das could still ask the SOTP treatment team or the Board of Parole for modification, and even if they say no, he could proceed through 17A to challenge the denial of his negotiation.
With permission, Chief, could I ask a follow-up? What is the state's interest in banning attendance at church or requiring permission to attend church? And could he have been revoked simply for going to church without permission?
It's my understanding that the purpose of that is the group gathering aspect. And again, there's no allegation that Mr. Das was violated for that or that there was even an allegation he wanted to go to a religious gathering. I recognize that on its face there's questions with that, but in this limited case, this court should decline to conduct that analysis because...
Would it have been futile for him to ask for permission to go to church?
I wish I could give you a good answer on that. I would like to think no, it's not futile, but I cannot tell this court definitively one way or the other. But he would have those avenues beyond his parole officer to say, my parole officer's not letting me go to church. Please, Board of Parole, let me go to church. And even if they say no, 17A, and it would be resolved at that time. It's for those reasons we ask you affirm. Thank you.
Thank you. And you may reply.
Thank you, Your Honor. I would like to follow up on the example with giving Mr. Doss's or somebody in Mr. Doss's position, their parole officer, the opportunity to be put on notice when their offender would actually use the internet. Now, even in that hypothetical, this is still an example of some sort of an individualized finding that this particular offender would need their parole officer to be watching them every time that they're on the internet. But again, this needs to come prior to this condition being imposed. So even if in this hypothetical, we were still staying away from the complete and total ban.
I'm not saying it's constitutional or not. And again, it's only for the duration of SOTP, right?
Correct, Your Honor.
But it's not that there's no reason for it all. I mean, the parole officers generally want the offenders to succeed, right? They want them to be rehabilitated. That's when they're doing their job, that's what happens, right?
That is correct, Your Honor.
Didn't we, in Ashbrenner, say it was okay to require disclosure of the internet, the name you're using to go on the internet?
Certainly, Your Honor, and those are the internet identifiers. I believe that's how the court characterized them in this case. But when we take a look at this restriction, we can see the narrow tailoring that was put in place. First of all, it was required only to see the names. They did not require to provide passwords. They did not require to provide any other information. And the state's interest was clearly defined in this case. When somebody moves to a new neighborhood and they want to check out who's around there to protect their children from them, absolutely. If you want to take a look at the internet and see what usernames they're using, absolutely. That was a ban that passed constitutional muster because he was detailed and he was tailored when we could see the relationship between the two. But we don't have this in Mr. Doss's case at all.
Counsel, if I might, under 822, we're here to analyze whether there was a lawful basis for this revocation. And there were a number of bases, there were a number of grounds that this revocation happened on. And I don't see that the constitutional grounds that you're raising as being any of them. Am I wrong about that?
Your Honor, I think that they're sort of combined. I do know that one of the bases of his revocation was using the internet to admittedly look at pornography websites, but also to go on dating websites. So both of these, using the internet and going on dating sites, trying to exercise his right to association and engage in a romantic relationship, those are both rules that we challenge the constitutionality of them, and they were the basis for his revocation. So we do believe that 822 was the proper venue. And I would also point this court's attention to the decision in McGee, where we had a similar situation. McGee was in a similar situation than Mr. Doss, with Mr. Doss. And what the court tells us that even if we have violations that would have been properly challenged under Chapter 17A, but we also have violations that the proper venue is under 822, the court still proceeded and allowed Mr. McGee to actually challenge these conditions under Iowa Chapter 822. I would like to also touch on the point that Mr. Doss did raise two arguments on appeal. He claimed that his trial counsel was ineffective for actually misinforming him of the magnitude and of the practical implications of these conditions. Now, Mr. Doss testified and said, as long as I follow the law, I would be okay. Well, we know now that this is not true. Now, I'll try counsel, and we see the argument that perhaps even if this court assumes that these are not direct, or even if the court does not engage in the analysis as to whether these are direct or collateral consequences, the fact that he was misinformed should render Mr. Bennett, Mr. Doss's trial counsel, ineffective for providing that advice. Because the consequences, as we now know, are of very substantial importance to Mr. Doss. He testified extensively at trial as to what these conditions would have meant had he known. For example, not being able to travel out of county. Well, that was important to him because he lived 2 hours away from family. And that would have come into consideration before he made such an important decision as entering a guilty plea. Now, briefly, I want to touch on the prejudice element. Mr. Doss's testimony, again, is extensive, that he would have not pled guilty had he known all of these rules. And the state's argument is that this is a self-serving testimony. But I would point this court to the original trial docket. That, even though it was not extensively pled in the PCR trial, when you take a look at this docket, we will see the motions to produce, we'll see the notices of depositions, we'll see the motion in limine, and all we know is that this case was getting ready to go to trial, and pled probably about a week before this trial. So also when we take a look at the offenses, he was charged with a sex abuse in the third degree, which is a C
Let me
felony.
wrap up.
Yes. Your Honor, for all these reasons, we would ask that this court remand this case to district court and grant Mr. Doss's application for post-conviction relief, vacate his revocation of parole. Now, we would also ask this court to give a very serious consideration to the argument of the ACLU to direct the Iowa Board of Parole to put a mechanism of individualized consideration of the offender and the particular offense before imposing parole conditions that would intrude upon First Amendment and Iowa constitutional protected rights. Thank you.
Thank you. The case of Doss versus State is hereby submitted, and we'll take a brief recess to get things ready for the next hearing.